you, everyone. Welcome you to this special meeting of Council. I read the civic affirmation. We gather today to duly and faithfully carry out our duties to the best of our judgment and ability for the advancement of this district and the benefit of all of our community and fellow citizens. And the Coorong District Council acknowledges and pays respects to the traditional custodians of the land and waters, the Ngarrindjeri people, whose ancestral lands on which we meet today. We acknowledge the deep feelings of attachment and relationship of Aboriginal people to country and pay our respects to elders past and present. We also extend that respect to all First Nation people. Thank you. Councillors, item 1, apologies. I have none, but I just note that Councillor Ling is on Zoom today. Item 2 is confidential council matters. Just prior to this, I might ask Tracy Riddle from Kelly Jones, might just give councillors a bit of a guide, a bit of an education around why you would or would not move any motion into confidence.
So, thank you. Through the Chair, it's simply just in terms of your consideration around whether or not to deal with this matter in confidence. Obviously, under the Local Government Act, the starting position is your meetings are open to the public unless one of the reasons under Section 90, subsection 3 applies. One of those reasons...
Through the Mayor, whoever's speaking, can they use the microphone?
We are, Councillor Ling. We'll just check it.
Okay. I can talk louder. Some of the reasons under Section 90, subsection 3 include for the receipt of legal advice is clearly one of the reasons it's covered, as well as if you're dealing with personal affairs of any person, and that can include the personal affairs of elected members as well as the Mayor. So they are certainly considerations to take into account in terms of the matter that you're going to deal with today. It is also worth considering that it's certainly open to you to resolve to move into confidence and have your discussion and debate in confidence, but ultimately in terms of your resolution and whether or not you propose to keep certain documents confidential is a separate decision. So you can, for example, choose to move into confidence to have discussion around the agenda item that you have before you today. You can choose to then resolve to do a number of things with that report. You then might determine to make an order that your resolution is publicly available. You can also determine to make the report publicly available if you choose to do so. So just because you deal with something on a confidential basis as an agenda item doesn't mean you're necessarily keeping that information confidential after that point. So you might determine that there are questions that you want to ask of me that are not necessarily matters that ought to be publicly available information. I can also tell you, subject to what questions you may ask of me, for example, in relation to the redacted matters are in the report, are not matters that I can give you responses to if the council, has not determined to deal with this matter in confidence. So there might be, if you determine to this item remain open to the public, there might be some answers I can't give to your questions.
Tracy, can I just ask this question? It's been out in the public domain for ages. You get sick and tired of asking questions about the council, how it's operating. So there's probably people sitting there now wanting to know what's going on.
Yes.
So why do we go into confidence when all this is out in the open anyway?
And so that's certainly something that you need to turn your minds to individually as elected members in terms of whether or not you would vote for the matter to be dealt with in confidence or whether you choose not to do so. But what I will make sure, though, if you do determine for this matter to be dealt with, publicly, while the meeting's open to the public, I will need to be careful in terms of some of the responses I provide to you so that I don't actually, so that council is not in breach of its obligations under this Act or other acts.
Well, I would expect that anyway.
Councillor Bland.
Yes, thank you. Tracy?
Yes, Councillor, microphone.
In receiving the report, there are significant sections blacked out. Guess what it is exactly was in those sections, particularly if you haven't been party to some of the processes that have gone through here, and not all councillors have. So I find that that document interesting to read.
Yes, and I can't tell you while they're blacked out, while your meeting's open to the public.
So we can ask that question when we go in.
If you choose to deal with this matter, if you choose to
Go
make
in.
an order under section 90, subsection 2, I can, to a degree, answer some of those questions, but I can explain that to you further if that's how you choose to deal with this item.
So this document, even so, would not become public.
If you choose to make this document public, it would be in the manner that it appears to you now. It would still remain redacted like that.
Thank you.
Councillor Hill?
Tracy, just a question. If there are a couple of points in there that I believe are in dispute, wouldn't it be best to go into confidence and deal with them and then perhaps bring it back out of confidence?
And that's certainly something that would be a relevant consideration in terms of exercising your vote as to whether or not this matter ought to be dealt with in confidence.
Any other questions around this process? Okay, so we'll invite someone to move us into confidence or not. It's pretty straightforward. If no one is prepared to move into confidence, we'll accept that. So that means we move on to the agenda item, which councillors you'll be aware is now in the public domain, or can be. But the report will become in the public domain.
So if we just pause at that juncture, so if we don't move into confidence and if this matter is now dealt with while the meeting's open to the public, this report automatically is now considered to be a public document.
Does everyone understand that?
I can't hear it.
The councillor, can you hear me?
I can hear you. I can't hear Tracy.
At all, or?
Well, obviously I can hear her, but very low in audio like you were when you started. So something's wrong with the microphone. She's not using it.
I see it's directional, so you've got to make sure you talk.
Talk straight to it. Councillor, the council has chosen, including you, not to move into confidence. At this stage, that's how I'm taking it. So we're moving into the item, and so the report is now considered to be public. So perhaps now we're into agenda item number 2, confidential council matters in relation to it. There's a recommendation, but I would anticipate that perhaps our legal representative here, Tracy, could perhaps just give us a précis or an outline of the report, please.
Mr Mayor, before we do that,
Yes?
may I have a question?
Yeah, you can always have a question, councillor.
Thank you. And that is, do we have any live codes of conduct still? As a councillor who is not involved directly in code of conducts, I never know what is before us. And I find that, hence all the blacked out, difficult.
So councillor, as you're aware, all code of conducts are confidential till they're completed.
However, the numbers of code of conducts that may still be outstanding, do we have any?
Well, councillor, I'm not in a position to answer your question, because therefore I would be confirming if we did have some, wouldn't I?
But not the content.
Well, that doesn't change
Thank you.
that I would be confirming something that I can't tell you is or is not happening.
Thank you. I am concerned for the ratepayer and the amount of money we are spending over time, with all due respect to Tracy, on opinions and lawyers.
You may, but council's position, as you know, has been once an item is completed, council's policy is to bring it all into the open, so at least the ratepayer sees it then. But
Thank you.
we're not in a position to tell you whether there is or is not. Tracy. And councillor Lang, you better tell us if you can't hear, please.
Thank you. Can you hear me now, Councillor Lang?
Thank you. Yes.
Thank you. So in terms of the desktop review that we were engaged to complete, the report is self-explanatory in terms of the background to that. And, as members are aware, there had been a number of matters before the council for its consideration and determination that in a number of respects were interrelated. So we were engaged to review a series of complaints that had been previously made, as well as in a series of resolutions that were made by council at its March meeting of this year. Our role was simply to determine whether or not each of those matters had been received and dealt with in accordance with the council's obligations under the Act, as well as with its procedure that is in place in relation to the receipt and management of code of conduct matters. Ultimately, our findings were that each of those matters had been received and been appropriately dealt with in terms of particularly the code of conduct matters. We also then provided some advice around, the questions on, with and without notice provisions under Regulation 9 of your local government meeting procedures regulations, as well as some advice in relation to the most recent resolutions at the council meeting of March of no confidence in the mayor, as well as whether or not there is power for the mayor to require people to provide apologies or not. That really, by overview, is simply our role we played in the report that we've prepared. And probably my time is best spent answering any questions that you have in relation to matters that are in that report.
Okay. Start with you, councillor Roundtree, and we'll probably try and stick to questions, not statements initially, please.
Sure, no worries. Thank you, Mayor. So I have probably a few questions and a point of clarification that I wish to seek. So how, after reading this report, how do we redeem the reputation of this council, noting that the local and state papers have now done a story on this situation? I note that the advertiser journalist Colin James, who wrote the article, must have been in Meningie at some point to take photos of Councillor Lang and then to Tailem Bend to take a photo of this building. And we know it's recent because it includes the flower bed. So we've got a lot of damaging information out there. How do we now redeem the reputation of this council? And following that, what are the consequences of an experienced mayor bringing up this motion, which has brought our council into disrepute, and denying the mayor his procedural fairness? Where do we go from here?
So through the chair, so as we've noted in the report, the use of the vote of no confidence in the mayor is not simply something that is restricted to the mayor. We've certainly seen in the past that it has also been used with respect to actions and behaviours of elected members as well. It is no more than a public statement of a particular matter, as we've written in the report. I certainly, if you have concerns in relation to the potential for reputational damage, if the mayor considers he has had personal reputational damage, that would be a private matter for him to consider and deal with. If you have concerns then in relation to the more broadly considered reputational damage for the council, then it's certainly open for the council to consider whether it wants to make a positive statement in terms of the actions and behaviours of its mayor. But again, that will always be a decision of the council as a chamber and not an individual decision of individual elected members, because when you come together as a council, as a governing body, those decisions are the decisions of the council.
That's your first or only question?
I have a couple of others, but I'm not, I think.
You're happy to defer for a while?
Yes, I'm
Councillor
happy to do something
Bland?
else.
Actually, I would like to ask Councillor, through you, Mr Mayor, Councillor Roundtree made a statement that the journalist must have been to Meningie or to here to risk pictures. I'd like to get some clarification on that. A, how does she know that? And B, is that in fact true?
I can ask the
Point of
councillor if
clarification.
she wishes to clarify.
So thank you, Mayor. The photographs in the online version and the print version tell you where who took the photographs. The photographs of Councillor Taylor were provided by the journalist who had done a story on her. The photograph of you, Mayor, was provided from stock photos. And the photograph of Councillor
Not my
Langdon.
best photo either, councillor.
No, that's probably true. But the photographs it was just interesting to note that the photographs taken of Councillor Lang were taken by the journalist who did the story at Meningie. So that journalist has been to Meningie to take those particular photos because he's credited as supplying the photos. And that's quite significant because journalists don't put their names on other people's photos. They only put their names on photographs that they actually take the photo of. So I think there was, to me, a question that needed to be looked at there as to whether that was significant. And also the building here at Meningie, at Tailem Bend, we've got a lot of stock photos of our building. The one that was used in the articles had a picture of the new garden bed, which is recent. So you can see that in the photograph. So that journalist has also been to Tailem Bend to take that photograph as well, and he owns those photos. So to me, that provided a fairly significant linkage. I'm not accusing him, I'm just saying it needs to be looked at.
Okay, back to you, councillor Bland. Is that the answer you required?
Through you, Mr Mayor, there's still assumption in that, and I will leave it at that.
All right, we're open for questions. Councillor Taylor.
Through you, Mayor, what about reputational damage to elected members? What is the recourse open to elected members?
So our advice is and has always been in relation to those types of issues, and it has come up before in Ombudsman's reports as well as statements made by former ministers, that if individual elected members consider that they have suffered reputational harm, that is something, it's a personal private matter for the individual elected member to seek their own legal advice in relation to, in terms of managing that. It's not something that except in extraordinary circumstances, it's ordinarily not something you would expend public money on in terms of individual reputational damage for elected members. It's a personal private matter.
Councillor Rountree, has no one else got their hand up?
So further to that then, if it's the damage that has been done to the reputations being called an aggressive bullier and harasser, those sorts of comments are very damaging in this climate. They were done in chamber, they were done publicly. Why do we need to expend our private resources to deal with that?
So through the chair, again, it comes back to the role of councils as public authorities and to you as public officers. And there are a number of cases, particularly on the eastern seaboard, which talk about, when you take office, you take the slings and barbs and the arrows that come with that, in terms of that robust debate, in terms of that criticism that you might occasion unfairly at times from might be from elected members, but more often than not from residents, ratepayers. And what we certainly see from those cases is there's an expectation that you will have a thicker skin than a member of the public. So that's the starting position, the expectation, unfortunately, that that comes with holding public office. The second step then is, unless in exceptional circumstances, we've certainly seen some councils resolve to expend public money in terms of defamation proceedings for a former mayor down at Port Adelaide Enfield who was the subject of an ongoing systemic bullying, harassing, inappropriate behaviours from members of the public. So that was determined that was an appropriate expenditure of public money. And we've seen it for CEOs, if the CEO, is the subject of that type of barrage as well, or potentially senior administration staff. There is a role for the local government authority in terms of, assisting at times if a concerns notice is issued to an elected member or to a senior staff member. What I mean by concerns notice is under the Defamation Act, the first step that needs to be taken is a letter is issued by the person who feels like they've been defamed. They send that to the person that they consider has, caused them, that reputational damage. And in that concerns notice, it needs to set out, the actions and behaviours said to give rise to that reputational damage, and then sets out a proposed resolution of that. Until you go through that step, then it's not open to file defamation proceedings. So certainly the local government, authority is involved with the assisting councils in those types of matters. But if any individual elected member or any individual staff member was proposing to actually go down that road and issue that concerns notice with the potential for there to be defamation proceedings, that's where we say that is a personal private action, in more often than not, unless we've got those exceptional circumstances like the former mayor at Port Adelaide Enfield. Because it comes back to the expenditure of public money, it comes back to, these cases that say the requirements that you have a thicker skin when you take public office, and in terms of the slings and the arrows and the barbs that come with that. Obviously, the starting position as well, is always to try and ensure that, the elected members have a good working relationship and make sure that the business of council is, that you just get on with that in terms of your operations as individual elected members as well.
So the next councillor is Councillor Qualman, then Councillor Hill at this stage.
Thank you, Mr Mayor. Through the chair to Tracy, I got a short comment now because you've partly answered my question, and because I had concerns about someone, elected member or someone on council does a serious breach of conduct and to take down someone's reputation, that then should be via the public money or what you spoke about, or through the local government, and that was my concern, but you've just answered that quite comprehensively. Thank you.
Councillor Hill.
If someone does bring a case of defamation against someone else, that would mean that all records would be open to subpoena by the lawyers involved. That includes emails, text messages, Facebook messages. Is that correct?
So, again, the starting position would be the issuing of a concerns notice before then defamation proceedings are filed. And once those, if you get to the point where the proceedings are filed, they needed to be supported by affidavit evidence, and that information, the evidence in that affidavit then needs to set out what caused the harm and the reputational damage. If it's going to come back to what was the publication and what was said and what was disseminated that gave rise to that reputational damage. So if there are things that have not been said or have not been released or have not been made known or public, they are not relevant to any defamation proceedings. It would only be things that are published that would be relevant to those processes. The other thing is, look, I would absolutely caution, I would suggest that, anybody that was considering these types of proceedings, go and separately obtain your legal advice in relation to this. I'm just giving you an overview of what the process is. They are lengthy proceedings. They are expensive proceedings. They are public proceedings. So if you think that there's media attention now, if there's affidavits filed in defamation proceedings, that's going to be something that would be of interest. They are also very specialised proceedings, and so not only will you likely need a solicitor, but you might also be looking at having to engage a barrister as well. So, we're certainly talking about, a very long, lengthy process. There has been these types of proceedings brought in the past, and I certainly know they go well beyond the term of any government, any council.
I might just put a question in. I think Councillor Brown, you're next, but Tracy, could you just sort of give us a guideline on, for want of a better word, where the benchmark or the marker point is of a bullying claim, or do you know what I mean? Like, at what point and how is the best way to bring that forward?
So if any individual elected member, or indeed if any resident or ratepayer considered that an elected member had bullied or harassed them, then the Code of Conduct for council members makes it clear that any person can bring a complaint under the Code of Conduct. And so the provisions under the Code of Conduct clearly speak against bullying and harassing staff, bullying and harassing each other, or bullying or harassing other persons. There's also provisions obviously under the code in terms of ensuring that your communications with each other as well as with members of the public are respectful, conducted in a respectful manner, non-discriminatory, ensure that you are at all times, meeting your obligations as, public officers as well as, elected members of the council. So it's the Code of Conduct that sets out the expectations of behaviour of elected members. Anyone can make a complaint. It's often thought that perhaps only the person that's directed at can make a complaint, but it's not. Anyone can make a complaint under the code. Then it always then is received, and as we've set out in the report, any complaint needs to be received and assessed and dealt with under the council's procedure that's in place, and a determination made, whether or not those actions and behaviours could be said to give rise to a breach of Part 2, and if so, then what's then open for receiving and managing it? Is there an opportunity for it to be dealt with internally? Does it need to be sent for external investigation, or is there simply, nothing in it? There are a number of definitions of bullying. The ones that are most often relied on are those that are contained in the Safe Work SA guidelines, which are drawn from the Australian Safe Work guidelines. Bullying has always been considered to be something that is sort of ongoing. So it's ongoing actions and behaviours rather than the once-off. But we also do need to turn our minds to what the code actually says is bullying and harassing. So harassment, is more broad than what might be found to be a definition of bullying as well.
Councillor Bland?
Thank you, Mr Mayor. I'm just going to move that slightly to another question, and that is 5.18 from the report, which refers, we note Councillor Taylor was an apology for this meeting, and it was understood that she would be an apology, taking leave to raise money for charity. I would like to declare now that I was uninformed in relation to Councillor Taylor still being away. I do not follow Facebook or other people's personal lives, and I would appreciate knowing how it was understood, because it was not in the agenda as an apology, and Councillor Taylor had previously, during this event, as if my memory is correct, had in fact Zoomed at one stage. So at no point, as I understand it, was I aware of the time frame, the exact time frame Councillor Taylor was away, and I am not sure if others are in the same boat. So I would like to know
Or
how
canoe, councillor,
the word
or
was.
kayak,
Sorry?
in the same kayak.
Well, other councillors weren't in the same kayak, otherwise I would have known. So I guess my question is how it was understood, because I actually did not know, nor do I remember any formal notification.
So
These
through
councillors.
Through the chair, we had understood that was something that was notified to all elected members. So certainly happy to amend. That weren't aware of that. Nothing turns on that sentence in terms of the findings.
If I may continue, Mr Mayor, I would appreciate that being adjusted from it was understood. I was certainly aware she was on a kayaking event for charity. However, the time frame, the exact dates, where she was, and when she could or could not Zoom was not to my knowledge. Thank you.
So through the chair, I'm happy to amend that sentence to read, we note Councillor Taylor was an apology for this meeting, and it was understood by most members that she would be an apology, taking leave to raise money for a charity event.
Thank you.
I'm just going to take, in response to that, Councillor Taylor, and I'm just on that particular point though. Yeah.
So on that particular point, I send my apologies through to Ashley.
Yep.
I do not send my apologies through to the rest of the chamber. And regarding the mention of a zooming into something from the 1st of February to the end of, or almost the end of March, I did not Zoom.
I can't
From
recall,
anywhere
I can't
while I
recall you
was on the
successfully
river.
Zoomed.
So
yeah.
suggesting that I Zoomed while I was in a kayak is incorrect. And I'm sure that Ashley will be able to pull out from her emails when I informed Ashley that I would not be attending. And I did inform Ashley that I would not be attending. So there's no, if there is a suggestion that I didn't tell anybody that I wasn't going to be attending, that's inaccurate.
Mr Mayor, if I
The
might
question probably
respond.
turns on whether all councillors were aware aware that
I'm
the
not arguing.
reasoning for your Zoom.
My point wasn't that whether or not Councillor Taylor had informed council or yourself proper, it was that as a councillor, I did not know.
Yeah, and
Sorry.
in the old days, we have the old leave of absence, councillors,
Correct.
but that's around 3 months generally.
So through the chair, can I just ask a procedural question? So was Councillor Taylor's apology noted on the agenda that went out?
No.
Excuse me, may I just add to that, please?
No, not yet, just wait on. It wouldn't normally be noted at that point because there was no leave of absence process, which, councillors can apologise at any point to the start of the meeting for no particular reason if they wish, as I understand it, but I think it's just there for noting, councillor, to be quite honest. I'm going to go on with the order I have written when I find it.
Excuse me, Mayor, this
Yours
is,
in direct relation to that little point, is it,
Yes, it
councillor?
is.
Right, well, you need to be
Yes.
very direct about
I'll be
that.
very direct. So at the beginning of the last meeting, I gave a speech as to Councillor Taylor, acknowledging, we asked for acknowledgements. I gave an acknowledgement at the beginning of the last meeting, acknowledged Councillor Taylor's work in having raised money for prostate cancer and her being on a kayak. So right at the beginning of that meeting, everyone was aware that's where she was. and why she wasn't here. And I did that as part of our formal acknowledgement at the meeting.
Okay, I'm going to, unless it's directly in relation to this point, councillor Hill, I'm going to move on to the
Yes, it
next
is.
speaker.
I think the inference that perhaps councillor Bland was referring to was that there was some indication that we all knew that councillor Taylor wasn't going to be there and ambushed the meeting, as in the words of councillor Roundtree during that meeting, that we ambushed you, and in full knowledge that councillor Taylor was not going to be there for the vote.
Correct.
That's what that inference was. That's why we brought it up.
So through the chair, that's not the intent of that sentence. And with the amendment that's been made, it was understood by most members that she would be an apology, taking leave to raise money for a charity event. As I understand it, that's a correct statement.
I'm not challenging your interpretation of that, but that was the inference on the day when councillor Roundtree walked out of the meeting, was that we had ambushed the mayor in full knowledge that councillor Taylor wasn't going to be at the meeting, and we didn't know councillor Taylor wasn't going to be at the meeting until that acknowledgement was made at the beginning of the last meeting.
So I'm not going to actually, I'm going to stop that now.
Okay.
So councillors, you make the decisions on whether you're at the meeting or not at that time. So the question of prior information is probably not really material to the process. If you aren't in the room, or you aren't, I've determined that you fell offline or whatever, you're not at the meeting. And that process, and if we have a relaxation of the emergency procedures, I would trust we might all come back to the chamber. One of the more interesting challenges of the last 2 and a bit years is having meetings that are split between Zoom and non-Zoom. I'm going to move on. I'm going to move on to councillor Jentsch was the next speaker, and then councillor Roundtree after that, this stage.
Thank you, Mr Mayor. Point of clarification in regards to the motion. I took no account into who was either going to be attending or not. The motion was going to be, I had determined that I would put that motion irrespective of attendance on the day. And as you've stated, Zoom is used, and therefore there was a level of presumption that Zoom, because of proximity of where the councillor was, may have been an option. My other question, Mr Mayor, is the material that has set this sad case of events in play, whilst a discussion, I believe, at the last meeting, CEO indicated that whilst councillors may have put confidential on them, they aren't necessarily confidential documents of council.
Point of order, Mayor, is this a question?
The question is,
So
are the public able to see that? Is it appropriate that the public see those documents? Because we are now talking litigation. We are talking...
Councillor, stop. I don't know who's talking litigation yet. I'm going to stop you there. Your question is,
Why aren't we making...
are the documents, which this council, no one moved to move into confidence, I might point out, are the documents that you said were confidential, what's their sort of status in this? Is that referring to the emails between the 28th and the 31st, councillor?
Correct, and it's the presumption of confidentiality that I'm...
Tracy, you've got a reasonable answer with that.
So through the chair, look, what all elected members, as well as council employees who are equally bound by these provisions, need to understand that there is a number of levels and ways in which documents ought to be considered confidential council documents. So, very clearly, if the council goes through its formal processes under the Local Government Act, under Section 90, subsection 2 to move into confidence, and then makes an order under Section 91, subsection 7, that the reports and the documents and the item is to, remain confidential for a period of time, that very clearly is information that is confidential council information. But then there is also a level of documentation and information that both administration as well as elected members will receive in the course of giving effect to your roles and responsibilities that is clearly confidential council documentation. So internal emails between each of you ought to be very carefully considered as to whether the confidential status of that, because there are a number of matters that, you might email each other about that relate to confidential council items that have either been dealt with by that formal process, or that there ought to be a clear expectation that it's confidential council information. So you might be talking about, for example, an upcoming tender process, or, you might be talking about sensitive personal information of a resident or ratepayer. The Code of Conduct specifically references under Part 3, it talks about if an elected member breaches, releases confidential council information, whether or not there's an order, made under the Act, the wording used is, or ought to reasonably know is confidential council information. So just because there hasn't been an order made under sections 90 and 91 for something to be kept confidential, doesn't mean that something is not a confidential council document. So there might be any number, for example, of information reports that you receive from the CEO that should be treated as confidential council information, even though it doesn't come to you in the chamber to make a formal order in relation to that. So the nature of your internal communications should be considered to be confidential council information.
Councillor Rountree, you were next anyway.
Thank you. I just back one step, and then I want to get a point of clarification. Back one step, on the 25th of January, I emailed the council to let them know that Councillor Taylor was undertaking this journey. And I attached a story that was in the Murray Valley Standard, which talked about her trip taking 7 to 8 weeks. So the information was sent on the 25th of January, letting everyone know, and it would be a 7 to 8 week trip. And it's also included in the March minutes that I acknowledged the efforts of Councillor Taylor. And a thank you was received from Bridget. My point of clarification is, and this was around the issue of whether we should have acknowledged or a conflict of interest when dealing with this matter, which I thought you'd raised twice in the document. I think looking at what you've suggested and reading section 75 myself, that we should have done that. I think at the time, could it be perceived that somewhat it's convenient when all the team members, and I'll use the word team because that's how this was referred to previously, have code of conducts levelled at them all at the same time, which in fact could take out that whole group of councillors when it came to making a decision. So what my point of for clarification is that if we had declared a actual conflict and then we chose to stay in the room to vote on the matter, would that have been an appropriate thing to do, to declare an actual but stay in the room and to vote? And would voting on that matter then lead to perhaps another code of conduct coming our way for staying in the room and voting on that matter?
So through the chair, as you have identified, in terms of the conflict of interest provisions, there are currently 3 categories that are recognised. That will change at the end of this year, but at the moment we have 3 categories, and it's material, actual and perceived. The only way to deal with a material conflict of interest is to declare that interest and to leave the chamber when the council reaches that agenda item. So an example of that obviously was the mayor at the March meeting when the motion of no confidence was initially raised. In terms then of, and that is the only way to deal with a material conflict of interest. In terms of the actual and perceived conflict of interest, there are a number of ways that a member can choose to deal with that. And it is always for the individual member to turn their mind to the agenda item, and if they have an interest in it, what level of interest might that be? And under those actual and perceived conflict of interest provisions, if you declare a conflict under one of those categories, it doesn't necessarily mean that you have to leave the meeting. You may choose to do so because you may determine that your level of interest as an actual conflict of interest or even the perception of that interest is so high that the only way that you can deal with it in a transparent and accountable manner, and that's what the Act says, is to leave the room. Equally, you might determine that it can be dealt with in a transparent and accountable manner by identifying it and just giving a short explanation that, the subject matter of the report pertained to you, but, you're very clear in terms of your roles and responsibilities as an elected member as opposed to, your personal interest, and that there is no conflict, in terms of you remaining in the chamber and dealing with that matter, including by discussing and debating and voting on the motion. Simply, the conflict of interest provisions just make sure that we take into account that when we make any decision in this chamber, that you are making it free from any personal conflict in relation to the outcome of the manner in which council is dealing with it. The actual and the perceived conflict of interest provisions are one of the very limited, or the only exception currently under the Local Government Act, where you could actually say, I'm proposing to stay in, but the way I'm going to deal with my actual or perceived conflict is to participate in the discussion and debate, but I'm not going to vote on the matter. So that's the limited exception to that rule. But equally, you could say, I'm not going to participate in the discussion and debate because I don't want to influence the way that that goes, but I do intend to vote on the matter. I'm going to exercise my vote. Or you could say, because I understand my role as an elected member and a public officer, and I am very clearly able to give effect to that, and there's not a conflict between that and my personal role, I intend to participate in the discussion and the debate, and I intend to vote. So there are, a number of ways that you can deal with it. It's just making sure that there was the identification of it. On the second occasion, for reasons that we set out in the report, because we do consider there was a live argument that those documents could have been released anyway without a resolution of the council. Our view is that that was less of a consideration in terms of dealing with it, because arguably they were already public documents. But certainly on the first occasion, in terms of receiving and dealing with code of conduct matters, members should turn their minds to those sorts of conflicts, because it pertains to their personal, the outcome could have a personal impact for them.
Does that answer your question, councillor?
Yes, that does. And that, I had read that section about 3 times the other night to really get my head around it, and I can see that we should have, but the concern at the time was it was being a whole group of us that would have just removed such a big group from the voting. I just felt we needed to stay. Yeah.
Councillor Taylor, I don't know if you sort of indicated, but I'm not sure if you want to go on with your indication.
So through you, Mayor, the original email sent by Councillor Roundtree followed on from a discussion which was around the conflict of interest in the chamber, which was how do we prevent, or is it possible, or can we identify a code of conduct where enough elected members are listed, which follows on from Councillor Roundtree's comments, where the number of elected members listed in that code of conduct then removes them from the chamber. What is the recourse for a member purposefully doing that in order to remove a large number of the group, so that potentially there's a vote on the back of that which either reveals the content of the document or allows them to vote in a different direction?
So through the chair, it would only be if the level of conflict identified was a material conflict of interest, where that would require then the member to remove themselves from the chamber when you reach that agenda item. So that's the only level of conflict where there is that requirement. If it's an actual or a perceived conflict of interest, then there are those 4 ways that I went through that could be dealt with, which includes being able to stay in the chamber and dealing with it. But we have certainly there was, several years ago in another council, there was a number of complaints made against an elected member, which were then investigated. It was determined that the member had breached the code of conduct. The requirements then under the code is that report then be received and dealt with at a public meeting at the council. Because there were so many elected members that were actually complainants and were involved in the investigation process that declared a material conflict of interest, the council could never reach quorum in order to receive and deal with that code of conduct report. So what the Act actually provides is that you can make application to the Minister to have an exemption from giving effect to the material code of conduct provisions, and that's what we did on that occasion. So each of the members impacted were provided with an exemption so that they could remain in the chamber, as well as the member that was the subject of the report on that occasion. So certainly that's a mechanism that can be used if it's a material conflict of interest, but that is a rare occurrence, because under the actual and perceived, there are other ways that you can deal with your conflict, which includes being able to remain in the chamber.
Further to that, Mayor?
Yeah.
On the question of confidentiality then, Councillor Roundtree made it plain in her emails that she wanted it behind a confidential wall. And the CEO has done her best to explain how confidentiality works in that setting. And my question is, at what point does the content included in an email exchange become a public document? If it sits behind a confidential wall, and is it protected behind that confidential wall?
But through the chair, so the starting position should be, if you are, as elected members, emailing each other in terms of council business that is either identified as a confidential matter or that you ought reasonably know and expect to be a confidential matter, then that is something then that you need to be turning your mind to, particularly in terms of those provisions under Part 3 of the Code. Now, I would suggest it would be a rare occurrence for any internal communication between yourselves or between senior administration staff for you to ever consider that that is publicly available information. Because simply, in terms of, being able to do the business of the council, if you cannot communicate with each other in relation to that, it would make it very difficult if you had to then constantly meet. So you should be able to have comfort that your internal communications with each other are to be properly treated as confidential communications. Now, they're not necessarily protected from something like a freedom of information application. And so frequently we see people make application under that statutory framework for information. Equally, just because you make an order under section 90 and 91 of the Act to keep matters confidential, so keep matters you deal with in the chamber confidential, that equally doesn't protect them under the freedom of information statutory process either. But the starting position is you ought to expect that those are confidential council communications, and if somebody wants to access those, they would be required to go through the Freedom of Information Act, and it would be received and assessed in accordance with that statutory framework.
Sorry, Councillor Arthur. Councillor Hill, you didn't indicate. No, I thought Councillor Arthur. You don't look alike, don't worry. Councillor.
Oh, okay. Whether this was a conspiracy, a mistake, or whatever, it's about time that we got on to do the job that we're here to do. Now,
We need to
as
get
you
to
know,
get to a
Mayor,
question.
we were at the.
Get yourself to a question of Tracy, please, and
Well, I'll make a
we're not in
statement with
debate
it.
yet. We're not in debate yet. I might point out.
Sorry?
We're not in debate yet. We're in questions
Well,
of our.
I think that's the only way you can answer it, unless we're just going to keep going round and round in
Well,
circles.
if councillors feel we've answered enough questions, we'll move to the recommendation or something else. But if you want to make a statement or enter the debate, I'll wait till everyone has had
Well,
all their questions answered of our legal representative.
we're here to do a job. This is guide the council and what's way.
Your question will be.
My question will be, I'll preempt and ask the question then, okay? As you know, at the LGA meeting last week, it was embarrassing to walk around and being asked all the time about what's going on with your council. Are you disruptive? Has anyone got... Are you able to work together? Are you able to do things? If you read the article, whether it was a set-up article in the paper or not, I don't know.
Do we have a question?
I'm trying to get him to it, don't worry.
So I'm getting to it. And as you know, I was at a show on Saturday where you were there. Your ear must have bled because there's about 90 rate players there. And all they wanted to do is, hey, what is the council up to? What the hell's going on?
Your question's going
My
to be.
question is, are the elected members here to sit down and do the bloody job they're supposed to be doing?
We just need to modify our language a little bit. I'm going to take that as a bit of a statement and a bit of a question. You can't really answer that one.
I don't think there's a response I can give.
We're nearly, I think, councillors, we're nearly near the end of questions. So Councillor Hill, though, sorry.
Speaking to this document,
Yeah.
but I do have a question for you, Mr Mayor. Do you record your phone calls when you're having conversations with
No.
councillors? Okay, because
So-
I have a different recollection of our discussions to what you have stated in here. And I will, I have a different recollection. So I didn't think I undertook to give you any answer by any time frame. You asked if I was interested in doing mediation, and I said I think it would be a waste of time because I think the council is concerned. Now, keeping in mind, I never named any councillor. You named the councillors
So
in
so
the council meeting.
your question to me.
So my
will be-
question was, yeah, do you record, because I have
No.
different recollection of our discussion to what you have.
No, no, I don't record my phone calls, councillor. I felt, and you may disagree with me, we had a civil conversation, if we remember. If we could
Yes,
both
we
agree
did.
on that, I think that'd be a fair comment, if I may.
And the last thing I think I said to you was, I'll think about it.
Yeah. And I thought differently as per the report, but I can take that on board. Okay, are we finished with questions in relation to this subject?
Mr Mayor, just following up on that, then the report needs to reflect that councillor Hill actually doesn't agree with that content,
With the last part of the
with that
content?
last part of that, because there are obviously two different recollections, none of which are able to be proven in any way because, and I'm very pleased to hear that you don't record your phone conversations, as we've had many. And I
Lengthy,
would-
councillors,
Sorry?
lengthy.
Lengthy, and it may still come up yet. And I think from that point of view, this needs clarification, as this is now a public document, about the fact that your recollections are both different.
So, probably look to the,
So through the chair, as I understood it, councillor Hill said she did end the conversation saying to the mayor that she would think about it.
and
that's my
for point of clarity, I took it that councillor and me may have a conversation before the meeting on Tuesday. Now, agrees with that. But also, there was actually never an opportunity, funnily enough, that day where either of us actually took it. So I take no offence or otherwise, councillor Hill, about that. Just as if you're happy with that to be an amendment or a minor change or a note, I think that'd be fair. That was my recollection as I wrote it down that evening.
Another question on a similar issue then, and it's a question to you, Mr Mayor. Given the anxiety around this issue, and it happened at one meeting, but it wasn't discussed by you and councillor Hill until, I think, the Sunday prior to the next meeting, was there any reason that you didn't make contact earlier so this could have been resolved and not end up in this document?
So, councillor, as you may recall, I think in the February period, the CEO was on leave for the first week or two after the February meeting, sorry. Got to get my meeting months right. And I think our executive officer was also on some well-earned leave. And you would know that I do take a lot of time to consider things. If that's to be taken as a criticism of me, I'll accept that.
It's not necessarily a criticism of you. I just felt
Yeah.
that councillor Hill was left hanging without any contact, and I felt that was, in reading this document, a concern.
And so one of the issues, as you'd note in the report, is the validity of a question. And if we recall the question in February, I said, and as I said in March, it would be preferable if I was given some forewarning or received that earlier. So that's the position I took. Now, as you can see in this report, it's not the preferred way. I've got 1, 2, 3 more councillors before we're about to move somewhere. I'm going to start with councillor Taylor, please.
Through you, Mayor. So the original motion includes the words aggressive bullying and harassment. There is no background or basis to the use of those words. What recourse do, and it later came out during the course of the meeting where I was named along with councillor Roundtree. Irrespective of who did the naming, my name is now attached to that motion of aggressive bullying and harassment. What recourse do I have to have that an apology for the use of those words, given that there is no evidence of aggressive bullying or harassment anywhere to be found in the background to the motion or in the document?
So, Tracy, or do you want me to have a crack at that?
So through the chair, there is a provision under the local government, the meeting regulations procedures in terms of making a personal explanation, in terms of providing an explanation in relation to that. So that provision operates that, with approval of 2/3 of the meeting, you can make a personal explanation in relation to a matter that's before the council. However, I would suggest that your question just now effectively addresses, your concerns in that respect.
Yes, I mean, my name has been attached to aggressive bullying and harassment. And therefore, what recourse do I have, apart from the litigation and legal action on my own behalf? What recourse do I have to have that removed? Because my name is attached to that motion.
So through the chair, the minutes are a record of a council's meeting. And so given that that was moved and seconded and dealt with by the council at that meeting, then it remains in the minutes. In terms then of, and as I understand it, and this meeting, is open to the public, you've given an explanation in terms of, refuting any of those types of actions and behaviours. However, if you do consider that, any member has breached the code in that respect, it's open for you to make a complaint under the Code of Conduct as well.
Thank you.
Councillor Roundtree?
Thank you, Mayor. Following on from what Councillor Hill just said, I would like to know how Councillor Yench came to be the spokesperson for Councillor Hill after that event. And reading the room at the time, it certainly looked as though Councillor Hill was aware that a motion would be coming forward. If she wasn't and she had no idea, then I would like to know how Councillor Yench became the person to have known all of the conversations that you had with Councillor Hill, and how he came to be the person that delivered such an opportunistic motion.
Councillor Hill,
I could probably provide some...
I think I'm going to let you respond to that statement.
So as Councillor Bland, I can't remember who it is now.
No, just go easy. It's fine.
During that month of February, I had Councillor Bland checking on my welfare and asking if I'd heard from the Mayor. I had Councillor Yench ring me and ask how I was and how I was travelling and had I heard from the Mayor. And at that point, I had not heard from you. I didn't hear from you until 3:51 on the 13th, which is the Sunday night before the meeting. I didn't have any further conversations with Councillor Yench after that, so therefore he was probably still of the understanding that you hadn't spoken to me. The first I knew of the motion was, as you know, we walked in late to the meeting and I was asked about, and we didn't have time to discuss anything, and then the motion was put, because I was actually still going to move my motion about asking for an apology at that stage, and he jumped in before me. That's how it was. But the reason he knew I hadn't heard from you at that point was because I hadn't heard from you at that point. That's simple as that.
That's fine. I don't want this to be a tit for tat, so
No,
I just don't know if there's
providing
any
an
question around the
explanation.
veracity of that at all.
And where did the assumption that it was aggressive bullying, harassment come from, which of team councillors? From the motion, I mean...
The beauty is
and
Councillor
also
Yench is the next speaker.
Did Councillor Hill at any time during that 3-week perhaps ring you to find out where things were at? I mean, there's a lot more I think that could be done on both sides before we got
Certainly.
to that point.
Councillor Yench.
Thank you, Mr Mayor. As of the February meeting, having sat next to Councillor Hill at that meeting, Councillor Hill was deeply shaken and was working very hard to hold herself together to complete the meeting. I was deeply concerned that her best interests were not being looked after in a caring manner, which should have taken place. I did make contact several times during the month with the councillor to verify her well-being and was informed that nothing had taken place at all. I base my assessment of what was going on from my own personal experience in previous council, as mayor and as a councillor in other councils. Previously, these issues were dealt with very early. They were not allowed to fester and to continue on. Unfortunately, this one did. When it came time at the last meeting...
Stop, councillor, stop. I am very concerned that you're alluding to previous what, I don't know, that happened in a previous council, which I do not know are in the public domain. That's my first point. I'm concerned that you're alluding to something that none of the rest of us that were not in that chain are aware of at all. So perhaps we need to get back to this, to what happened currently in this council.
Well, to tie that up for you, Mr Mayor, there are two councillors in this chamber who are aware of what went down previously.
Well, what went down is not a very good word, councillor.
Issues that involved.
I'm sorry, Mayor, but
This is out.
what has this got to do with this
I
current
don't quite
council?
know.
Well, Mr Mayor, I will.
I don't know.
I will drop that one and.
You
finish up
you
by
won't drop it,
clearly
councillor.
stating-
You'll actually withdraw it, please.
I'll withdraw that, but I will finish up by clearly stating that at the
We're in
last
questions to the legal counsel, councillor.
is that Councillor Hill was still desperately upset, and that should not have been allowed to continue. The councillor's interest should have been looked at more seriously. And that
So
is
your
my
question
statement.
is, councillor, your
And
question
that's
is, what's your question?
And the question is, therefore, Mr Mayor, because I was asked the question, that when councillors or individuals are in a state of stress, it is the role, I believe, of the person in charge
So,
to inquire as to and to assist.
so what I'll add, councillor, and I'm accepting you're not answering a question, is the challenge of leadership, as you know, is at what point have we got a bullying or harassment or a caring position to take? As you know, in the meeting in February, when the councillor asked me a question without notice, I said I would take it on board. The only other recourse, as I think has been shown in this report, is through the Code of Conduct. And at that point, and to this point, as I understand it, there is no other Code of Conduct in relation to this particular issue on foot. I suppose I've got two more questions. I'm going to start with Councillor Taylor, please.
For you, Mayor, at what point does duty of care kick in? Because I was mid-river when this motion was brought. I was not privy to it. I hadn't got a clue what was going on. For background, when one of the original emails came out, and I did not instigate the email chain.
Your question will be, sorry.
I've given you my question. At what point does the duty of care kick in, and from who? Because nobody phoned me either to say that there was content, private content had been released into an email chain.
So I'm going to ask the CEO. Yes, she speak. At what point do we, as the leaders of this council, feel that a duty of care kicks in? And
Through you, Mayor.
I'll start that. If I felt that within the barriers of robust debate, we'd gone outside of that, would kick in. Now, I accept people accept criticisms or concerns differently in this chamber, but at some stage I need to be able to allow robust debate without offence in this chamber. Now,
Respectfully, Mayor,
Yeah.
this wasn't robust debate. This was words being used, which eventually transpired that I was a target of,
Yeah.
which had a basis on email content which was released while I was aware.
Yeah.
And nobody contacted me to say, how are you feeling about the release of private information? How do you feel about that now being the basis of a motion in the chamber when you're not there to either defend yourself or stand up and say anything about it?
you want to have a go, Bridget?
Through you, Mayor, and Tracy. Generally, and I'll use those emails as an example, I was only CC'd into those emails, so in a sense, I let them just circulate because I wasn't party to them in that sense. The thing that I did do was to let councillors know, and from each of you, I see a different reason for having a "Are you okay?" conversation, and as Councillor Taylor just mentioned, nobody phoned her. In other cases, somebody does. That was when I sent to all of you the possibility of using the EAP providers as a vehicle for support during this process, but generally it's that type of activity that I would guide you to if there was an occasion to do so. So it's really as simple as that. I'm not sure, is that answering your question, Mayor? Is that what you're thinking? But it's really about saying where you can go from support, because I don't naturally assume that you're going to go to each other for support.
Councillor Rountree.
So my question is, when is it fair and reasonable for another councillor to take it upon himself to become judge, jury and executioner on a matter without anyone having a chance to defend themselves or have their own input? So that motion stemmed from a person deciding that he had made an assumption about what had happened based on a conversation and became the judge, jury and executioner of others who have now given us a great deal of stress to deal with, having our names out there. Now, he was the one who referred to the team council. I don't care how our names came out. I think I offered myself up as being involved in that matter. But the motion was already there as team councillors, and this was already heading in that direction. So when is it fair and reasonable for a councillor to actually do that?
But through the chair, and
On staying question still.
that is why our advice is and has always been, in terms of any proposed motion like this that has the potential to impact someone's rights or legitimate interests, that they ought to be afforded procedural fairness prior to the council's receipt and consideration and determination of it.
So the report shows that presiding member, myself, probably wasn't afforded that.
And through you, Mayor, nor were we as being involved in that motion. So what should the procedure should have been at the time when that motion was put forward and seconded by Councillor Lang? What should the Mayor have done at that point, so we're clear if this ever happens again? What should we have done?
So through the chair, so the Mayor declared his material conflict of interest at the time it was raised as he was required to do. And so there was no opportunity for the Mayor to do anything in relation to the matter because of its direct impact on him. What could have occurred, though, in the chamber is a member could have moved a formal motion that the matter be adjourned to another meeting for consideration so that the Mayor might have an opportunity to provide a response before the council provided its a vote in relation to the matter. So a formal motion obviously needs to be moved, seconded and carried by the chamber. Certainly that would have been our advice. It should have occurred in that manner. Or alternatively, the Mayor could have been invited back in, in these, quite limited circumstances. If the chamber wanted to deal with it at that meeting, he could have been invited back in and given an opportunity to respond at that time as well.
Thank you.
Councillor Hill, and I'm hoping, councillors, we're near the end of questions.
Question to Tracy. With bullying and harassment, a lot of it is in the eye of the beholder, isn't it? Because people can feel that they've been bullied and harassed. And if they feel they have been bullied or harassed, isn't that a reasonable assumption from somebody, regardless of whether anyone else agrees with it or not?
But through the chair, and certainly there is a very subjective element involved in allegations of bullying and harassment. And so certainly our experience has been, at times in terms of receiving and investigating those types of allegations, sometimes the words in an email simply speak for themselves. And it's very clear, even on an objective assessment, that could be said to be something that is bullying and harassing in nature. Sometimes those types of actions and behaviours are more subtle, and sometimes it might be simply a perception of someone that, when looked at from an independent, impartial third party, assessment is made that that's not bullying and harassment. I can certainly say from our perspective, in terms of any code of conduct matters that we've been involved in, if something falls into that latter category, our findings are always, we don't dispute that that might be how the person who has reported it feels, but on an objective consideration, it simply can't be found that the code has been breached in that way. So, sometimes these things are clear, sometimes they're more subtle. It's always about not dismissing how somebody, is receiving and perceiving and deals with those allegations, but that perception might not necessarily be objectively what's happening. The other issue is also, we do know some councils, if there are elected members experiencing, issues of difficulty or stress or concern, that, counselling sessions might be appropriate to be provided in certain circumstances.
I've got three more questions, and I'm indicating pretty soon we will bring this to an end. So I'll start with Councillor Hill. We'll go to Councillor Taylor. Sorry, Tracy. Yeah.
Through you, Mayor, on the back of that, on the question of bullying and harassment and its perception, can the release of private messenger or copies, screenshots of private messenger group threads which were pre-election and nothing to do with the council be construed as bullying and harassment to the person who is, of course, targeted by being named in those screenshots?
So through the chair, if any member felt that they were being bullied and harassed through that type of action or behaviour, then it's open for them to make a complaint under the code, and it would be received and assessed and dealt with under the council's procedure, and it would be an independent third party that would then make a determination with respect to that type of allegation.
Even prior to the election?
So if the action is the release in this current term, then it falls for consideration under the code now.
Okay. Tracy, Councillor Hill, sorry. Just want to have I think you might want to have a brief response to that. That's why I'm giving you an opportunity, I think.
Well, from what I've understood from my advice is that it's no different to relating a conversation that you had down the pub or a conversation that you've had down in a coffee shop or whatever. It's a conversation between people, and if someone chooses to reveal the contents of that conversation, unless it's defamatory, and that means it's malicious or it's untrue, that's my belief that defamation is that it's not true or it's malicious. I followed the thread that Councillor Roundtree started and responded in kind with an explanation. It used the words of the people that were involved in that conversation without any doctoring whatsoever, and it wasn't a screenshot. Those chats are available to be downloaded by anyone who was involved in those conversations or included in that chat group, whether they participated in that conversation or not. So what I did is I did a Facebook dump of all the chats that I was involved in or were included in the chat, whether I participated or not. And I went back through those threads after a meeting in 2019, and I don't think you really want me to be discussing that outside of confidentiality at the moment.
No, thank you, Councillor. I think we are wandering away from questions, so thank you for that. Councillor Taylor, you have spoken. I'm going to go to councillors, and I've got four more councillors. Councillor Roundtree, is that a point around that particular statement? Only if it's a point around that statement and nothing else, please.
Correct, all right. Releasing private chat group information in the manner it was done was irrelevant to the comment that I had made in my email, which was on the back of during a special confidential meeting where Councillor Taylor was attacked by Councillor Hill for saying something that she misunderstood that nobody else heard her say. So I was simply following up on that, going, we don't need to look like the bad guys here, we didn't instigate it. So that's where it started. Yep. I would also point out to Councillor Hill that when we did have a chat group that she was invited to be a part of, and when we deleted it, all of us understood that this would be deleted. We had no idea that she had kept it. And I'd also point out to Councillor Hill that her name is mentioned 410 times in that document as having said statements too, and I don't see her releasing any of the things that she said.
I am happy to release the whole Facebook dump and emails that I received during that.
What I'm going to do right now is I'm going to end that conversation around that. Because this is not a question to our representative now. It's not really going anywhere except exacerbating this situation. So I'm probably going to stamp down on that now. The next councillor, I've got four, and I think this point, when we'll terminate, and I really would like some more questions, otherwise I will ask you to bring this session to an end. Councillors Bland, Qualman, and I think Councillor Roundtree, you spoke, and Councillor Arthur can be the last speaker at the stage, if that's the case.
Thank you, Mr Mayor, and my question is to Tracy. And that is in relation to the process, in relation to the motion that Councillor Jensch moved in relation to the Mayor. And my question is, did you have an opportunity to look at the YouTube video of that to see how difficult it would have been to move forward when councillors, where the Mayor had to make a decision to leave the room, where 3 councillors left the room? And so were you able to look at that? And if so, what process do you think should have been followed at that? Because I found it particularly difficult sitting here when the Mayor it was on one issue, the Mayor still needed to run his meeting. He delegated to the deputy. 3 councillors left the room in protest, which is their right. How could have we moved forward effectively given the dynamics at that point? And I think I'm wanting that for advice.
Did, in terms of, so through the chair, you had 3 councillors leave and you had the Mayor out. Did you have quorum?
No.
So that's the first I'm aware of that.
Look, my understanding, sorry if I'm just reinterpret that.
Please.
I think you're saying 3 councillors left the meeting. They left the meeting after Councillor Jensch's decision.
Right.
Correct.
And so,
Okay.
Yes,
All right.
yes, sorry, apologies.
Okay.
And if I may sort of go on, so when I returned to the chamber and was notified of council's decision, and I think, Councillor, I looked at you actually, and I asked leave of the meeting in effect to go on chairing the meeting. I think you nodded if I can remember.
Correct.
The point was then that 3 councillors did leave the meeting, which leaves me with 5 councillors, which is still a quorum. So that's what my determination to go on with the meeting was, because I was of the view I still had a quorum. If any one more councillor had left the room, we would not have had a quorum.
I have no issue with the quorum going on. It was the dynamics in that heat of the time to assist the process. I agree with what you're saying. I'm just still a little bit confused about how we may have done that better.
So through the chair, as I mentioned before, so there's a number of options that were available to members under the meeting procedures regulations. And so it could have been a discretionary process to invite the Mayor back in. So, a member could have, raised a point of order and said, the Mayor's not been given an opportunity to respond to this and, seeking leave of the meeting to invite him back in to do so. Or it was open for a member to move a formal motion that the particular agenda item be adjourned to the next council meeting. If a member wanted to move that formal motion, it would have needed to have been seconded and then voted on. So if it was carried, then that item would then have been moved to the next meeting for the opportunity for the Mayor to respond. But certainly, in terms of that discretionary process, there could have been a point of order called and the Mayor could have been invited back in. Thank you.
Councillor Qualman, I've got you on the list still.
Yeah, thank you, Mr Mayor. Question/statement. I see that with regarding to bullying and harassment, and I just want to state that, if you can't contact the Mayor or you having difficulty contacting the Mayor, we have Miles here, the corporate manager, and we have also Ben Jarvis, I can't think of what his title is, as the go-to for when you have sensitive matters, harassment, whatever, in confidence, and talk to them. So I think maybe we should be utilising it a lot more, and I actually utilise it myself for some, not involving myself on behalf of the public. So they need to be brought into the realm of the whole thing too, to assist sometimes when the Mayor is unavailable, but also to give some more expedient feedback to people who are under stress or harassment.
So Councillor, you're referring to and I might get Miles to just respond to the exact role that yourself and the other officer take in this role. It's a public disclosure.
Through the chair, I think what Councillor Qualman's referring to is sometimes, and it's not so much that I wouldn't like a bullying harassment issue be directed to me. I don't think that's probably appropriate. But it's more where Councillor Qualman might have had the need to talk about some feedback he's getting from the public, and before he, formulates his ideas, sometimes he runs those past me, and that's reasonable.
Okay. Okay, I'm nearly there, and I'm going to take Councillor Arthur, as you're going to wrap up, and hope we're going to move on to some formal debate.
Well, now or?
I'm sorry, I'm going to take you, unless you, I'm out of question. I think
Okay.
we've had a fair go at the questions for an hour and 20 minutes by the look of this clock, so I'm nearly at the view of bringing an end to this short-term proceeding, questions, suspension, which has not really been short-term. But anyway.
Okay, first of all, I'd like to congratulate on putting the report out. Now, the report is quite long, it's quite informative, but virtually what it says is that we've got a situation where we've been talking now for the last 3/4 of an hour. He said, she said, he said, she said. It is quite obvious, and I think Tracy would agree with me here, that if you've got the complaint, you put a code of conduct complaint in, because that's the only way it can be dealt with and costs the council some more money. So, I think it's about time we wound this up, we accept the report, it's out there for people to look. There's been enough trashing of the Coorong Council's name now, and if those who want to, put a code of conduct complaint in, and then it's handled by a completely independent tribunal.
So Tracy, that's your final comment, is that is the process?
So through the chair, and certainly the questions we've been asked today, and as is addressed in the report, if any member feels like they've been bullied or harassed, or if they've got concerns in terms of any of those behavioural matters under Part 2 of the Code, it's open for them to make that complaint, and it's then received and assessed, and it's impartially dealt with.
Councillor Taylor, this will need to be a question, it's not. I think we bring an end to the short-term, the so-called short-term suspension has been somewhat longer, but nonetheless, I'd like to hear every question answered if we can. And I thank Tracy very much for her delivery of that. So with the leave of the meeting, we'll bring to an end that short-term suspension. Everyone agrees with that, I think?
Yes.
Yep. So, Councillor Taylor, are you going to move the recommendation is my question.
I will move the recommendation as written.
So the recommendation for everyone's benefit is that Council receive and note the independent desktop review report provided by Kennedy Jones Lawyers. And Councillor Rountree, are you the seconder?
Yes.
So, Councillor Taylor, you wish to speak to the motion?
I will reserve to the
Okay.
end.
Councillor Rountree, do you wish to speak to the
I'll
motion?
reserve to the end.
Anyone else wish to speak to the motion?
I'll speak to the motion.
Councillor Hill.
I find most of the report reasonable, apart from those couple of changes. I do find 4.6 a bit problematic because it indicates that I was threatening people. I was not threatening people, even though it might have been interpreted as threatening. If you read the whole message in context, there was no intent to threaten. I was using the information to release a report that obviously people aren't privy to the actual emails that are in question, which I find quite difficult because we've had a lot of conversation about a set of emails that no one has actually been able to see except those that were addressed to. The team ran on a platform of transparency and accountability. However, it appears that it doesn't necessarily apply to the team members, only to others. I don't know why Councillor Rountree felt the need to send an email after the January meeting, but she obviously saw the treatment as team councillors as somehow unjust and tried to convince us otherwise. I have a different take on the matter. I was just reminding that their motives were not totally altruistic and has contributed to the toxic atmosphere and divisiveness the council has now found itself in. My email didn't warrant the level of aggressiveness that came in the response, nor the insults and denigrating comments, which is one of my main points, was denigrating comments. This is not the first time a derogatory remark has been made about my character, and after presenting information about some activities by the team, it was suggested I provide a copy of the printout to the CEO. Councillor Roundtree interjected and asked, how do we know if Councillor Hill hasn't altered the messages, and said they were going to present their own report to the CEO. I took that as an unprompted slur on my character, and I did not take any action at the time then, or nor did I provide a copy to the CEO. So the other comment was made that I've been threatening and to use messages against the councillors for ages. I only use the message conversation to make a point, which I deem necessary, and it is hard for anyone to deny things when it's in their own words. I've had plenty of opportunity over the last 3 years if I wanted to be threatening and use those messages against anybody, and I've chosen not to because I tried to resolve it in a different way than putting a code of conduct in, because I am cognisant that there's been many codes of conduct and I was trying to save the council money. So the million-dollar question has to be, is why would a rational and reasonable person such as myself, who was recruited by and ran for the team and defended them in a letter to the regional paper against the accusation of being bastards, would then distance myself from the dominant group of council? Why would I take a stand and become a target unless I had a really good reason? I stood for transparency and accountability of everyone, not just the previous members of the council and staff, and I still stand for that.
Thank you, councillor. Anyone else in the debate around the recommendation, please? Councillor Yench.
Thank you, Mr Mayor. I'm in favour of, obviously, of having this information come out. And I do concur the January meeting, with that was in confidence. The debate in that meeting was extremely robust, but it was at times extremely harsh. The way that would have resolved all these issues is obviously not to have engaged in the email aspect that occurred a fortnight later. The next possible stopgap we had in all this, after what I believe was an impassioned plea for an apology, was for quite simply an apology. If an apology had been received, we wouldn't be dealing with this now. This is what it's about. It's about this chamber not being able to apologise. Unfortunately, where we are. Thank you.
Thanks. Councillor Bland.
Just on a point of clarification, Mr Mayor, and I'm assuming that the changes to the report, as per the discussions today with Tracy, will be made before it is released?
So through the chamber, as I mentioned at the start, at the very time that you resolved to not deal with this matter in confidence, this became a publicly available document in the form that it appears in front of you now. However, noting the questions that were raised, we will can provide an updated copy that can also be uploaded to the council webpage. So effectively, both will be there.
Thank you.
I'm looking for anyone else that's going to contribute to debate before I go back to the mover and seconder, who are both reserved. Councillor Qualman.
Thank you, Mr Mayor. Just briefly, I totally support this report. It is good that we've decided that going out to public because they need to know this, and it's more about being transparent and get it out to them so they can see what's happening, and let's move on.
Thank you for that. Anyone else? I'm looking at the councillors who haven't spoken besides the mover and seconder. Since the seconder hasn't spoken yet and the mover hasn't either, I'll go to the seconder first.
Thank you, Mayor. Also agree this report.
In closing, I might add, councillors.
Thank you. This report is a very good report. I think it sort of summarised things quite well. The team did stand on a platform of transparency and accountability and efficiency, and that those three things mattered. We came into this council at a time when there was a lot of distrust in council. A lot of things were happening that the ratepayers weren't happy with. There were unprecedented numbers of people attending meetings, sharing their concerns. We had a lot to deal with right from the day we got elected in trying to navigate through some serious issues that I obviously won't go into. This has caused a lot of friction. The assault in chamber back in the day caused a lot of friction, and perhaps if an apology had happened right then and there, things may not have escalated at that point. I take that Councillor Hill feels aggrieved by what was said. I respect Councillor Hill. I think that feeling aggrieved about what people say is in the eyes of the beholder. And whilst I will take on board that she never meant to say that her words were threatening, I certainly took them as threatening in her email, and hence a whole lot of things have transpired. I'm also very keen that we don't need to waste ratepayers' money anymore on these matters, and are very keen to see this move forward. However, I will also say that I think as a council, we have still, despite our differences, despite our feelings, have managed to continue moving this council forward. We have dealt with a lot of grant funding coming in. We've done a lot of very good things for the community out there. We've got our roads getting better. We've got infrastructure going on that's great, and ratepayers are happy. So even despite everything that's going on, I think in this chamber, when we're actually required to make decisions and do things, we've actually been able to pull it off despite the way we feel. And I think that's actually a credit to all of us, that we have put our hats on as councillors and gotten on with the job. And every now and then we get sidetracked by issues like this, which hopefully this will be the last of them before the new council is elected. And with that, I'll close my debate.
Thank you. Councillor Taylor, you'll close debate.
Thank you, Mayor. So the email exchange, of course, was the primer. And whilst Councillor Hill may not have seen the impact of her reply to Councillor Rowntree's initial email, I took great offence at that email, because the content really had nothing to do with the council, has nothing to do with the council, was pre-election content, was banter, was joking around, was a group of people having fun, not knowing what the outcome of an election would be. So regardless of who participated, there were some frank discussions in there. There were some real discussions in there. It doesn't belong in the public domain. It was a private messenger group. So to see that put into an email, I personally took it as weaponizing who we are, if you like, against us. I took great offence at that, considering where I was at the time. That came as a real shock to see that. I'll stand by the words that I put in that messenger group. A lot of it was good background for the individuals who were in the team. Not everyone, of course, in that messenger group effectively stood for election. So the content is, I would want to see the people included in that messenger group, their permission sought before anything was published in a public domain. So it came as a huge surprise to me that was being used. It was used. I disagree with it being used. I find that the report is accurate in its assessment. I think it's a warts and all. And unfortunately, I don't see the request for an apology. I could also ask for a request for an apology coming, but at what point do we stop? And I think if we don't stop doing this, then the deeper question is why? What is the motive for continuing to keep dragging up pre-election commentary and stuff from the past which bears no relation on the actions of this chamber? If we can't have robust debate in the chamber, then where are we going to have it? And if we can't send messages backwards and forwards to each other without someone taking an offence in the email system, then we better not send any emails at all. So I think the report should be made public, and this draws it another sad and sorry saying to a close. And it's time this council moved on. Goodness sake, we're almost at the end of our term, and we're still not moved forward as a group. So I await the elections in November, because I do agree with the mayor in that potentially that's the only way to stop this continual bickering, and provide a better service to the ratepayers. Because at the end of the day, it's the ratepayers who pay, it's the ratepayers who foot the bill. And in that, I will close debate.
Thank you, councillor. Okay, the debate is closed, and the motion before you is moved councillor Taylor, seconded councillor Roundtree. The council receive and note the independent desktop review report provided by Kelly Jones, and I'd note there's a couple amendments or additions or notations that's come out of this debate today that will be added. I put the motion. All those in favour? Those against? It's carried unanimously. Councillors, that was the only agenda item I had. So with that, we will close the meeting at my clock's a bit wonky here. 12:40. 12:40. And councillors, I think we're staying for workshops, but thank you, everyone.